Anyway, my practice is 3 equal parts. It's business. Have a lot of business clients, corporate work, limited liability companies, and any business you can think of, from physicians, construction companies, mortgage companies, insurance companies, bars and restaurants, everything you can imagine. Real estate, very heavy real estate, residential, commercial, agriculture, industrial. Less on the litigation these days, more on the transactional, buy and sell anything from a vineyard to a single family home, to apartment buildings, to warehouses, to vacant land. And then this area, which is estate planning and probate. And I affectionately call it the front side and the back side. The front side being us sitting here today alive, the back side being after you've passed, and whether that be if you were prepared, an administration dealing with a trust, perhaps, or a probate if you didn't have your affairs in order. And that's the way that works. And those folks have a little bit more of a difficult road, but we help them through that. And so it's that area that we're going to talk about. But for a lot of my clients, there's an overlap between business, real estate, and the estate planning or probate. Not the guy to see for a criminal matter, for a divorce, for a personal injury, or anything like that. But these areas are very interrelated for a lot of folks. And so you'll see me kind of go in and out of those, and I'm able to do that because I have that background. But in terms of what we're really here to talk about today, primarily is estate planning. And that is a comprehensive approach to dealing with our estates preemptively in advance before anything could happen. Certainly death, incapacity is another. And as I like to say, generally speaking, having your affairs in order, because that's what this is really about. So much of our life has been spent working so hard, everything from school to buying our first home, to getting married, having a family, having children, raising those children. And we're so focused on that at some point we kind of forget we've done pretty well for ourselves. We own a home, maybe we have some money, we have some retirement, some life insurance, and things are good, but things aren't necessarily in order in terms of our affairs. And what I mean by that is, as I say, we've worked hard. We may have a house, we may have a building, may have some rental properties, we may have a business, and things like that. And sometimes they're disjointed, they're fragmented. And what I'm going to be talking to you about today is bringing it all together, because at some point in time, maybe it's somebody's death, maybe it's having young children that cause people to start wondering, well, what happens if something happens to us? What happens to them? And maybe somebody has an experience with, at our age, a parent or parents and what they're going through. And we've learning through the good that, hey, look how well their estate went. They had a trust, they had all their affairs in order. Or alternatively, mom and dad didn't have their affairs in order. We went through this terrible probate. It was long, it was expensive, it was burdensome. Things didn't work out the way they wanted. And those are lessons too. And so for both of those reasons, we have a lot of folks that come and say, well, I think I need to get my affairs in order. And so really the way I as Tom mentioned, I have a PowerPoint. I ditch it right out of the gates. My approach is really to speak to you as if you were in my conference room, in my office, and speaking to me in that sense. And so really to start with, what I would say is we all need something, whether it be just a will, a power of attorney, a healthcare directive, or for those of us who have assets, gross assets that are 184,500, call it 185,000 or more, we need a trust. You're a trust candidate. And so that's really the place to start. For somebody who may not have those assets, it's pretty simple. You probably still may benefit from a will. A will at least deals with what property and assets you have, and you know, the things you'd expect, that you nominate executors and name beneficiaries who are to receive your assets. And then you may need still a power of attorney or a healthcare directive. But let me start with the trust for those people who need that, and that may be a lot of us here. Again, if you have gross assets of 185,000 or more. So if you own a home, it's pretty much going to put you into that category. And beyond, then you are a trust candidate. And if you don't have a trust, your estate is subject to probate when you die. If any of you are familiar with probate, anybody have any experience with probate? So what probate is it's a court administration of somebody's estate when they die who have more than $185,000. And so everything is viewed negatively in terms of the experience. So it's a court proceeding, which is started by a petition, and there's a lot of procedural hurdles to get through in a probate. And for, I always say for attorneys, even for attorneys, if they don't do this type of work regularly like I do, there's a lot of pitfalls. I've bailed out other attorneys that, oh, they have a family member and they tried to do a probate for them, but maybe they do criminal or maybe they do family, and they immediately went, I can't do this. I'm just fallen on my face. And so it's a lot of just procedurally heavy sorts of things that have to be done. And that's one part of it. The other part of it is the cost. The cost is exponentially more expensive. And when I say exponential, I mean like 10 times or more the cost of doing estate planning. And so, for example, let's take $1 million estate, which really these days is not a lot. I remember, you know, when I was young, my dad had always said, if you get a job that's 100,000 or more, you'll be set. Well, that's not as much these days. And $1 million, you know, that long past that, and $1 million is now becoming that too. $1 million is not saying it's insignificant, but in today's world, it's just not what it used to be. So, and especially given real estate and the values and that sort of thing. But let's take that as a marker. Take $1 million estate. The probate fees on that, the attorney's fees, are set by statute. They're called statutory fees, and it's 4% on the first 100,000, 3% on the second 100,000, and 2% up to $1 million, and then the percentage goes down as the amount goes up. So on $1 million estate, the attorney's fees are $23,000. The cost, meaning the court filing fees and bonds and other fees and costs, appraisal fees, are about $3,000 on $1 million estate. So now we're at $26,000. The person who serves as the administrator or executor in a probate is entitled to the same amount of the attorney's fees. So that's another $23,000. So we're talking right at $49,000, $50,000 in attorney's fees and costs for a probate on a $1 million estate. I promise you, estate planning is not $50,000. I wish it was. But you know, listen, it is what it is, and so that is a huge factor as well. Another factor is time. The average probate takes about 12 months, sometimes more, to complete, and nobody gets their money. Nobody receives their inheritance. Nobody receives their fee for serving as executor until it's complete, until the court has ordered the probate closed, approved everything, and therefore everything can be distributed. But that may take 12 months. Every county is different. I practice all over the state, but I primarily practice in the Valley, Fresno, Tulare, Madera. I also practice in Orange County, San Diego County, and a little bit in Los Angeles County. I have offices in Irvine and La Jolla as well. The bigger courts are a little bit slower. Fresno takes on average, if you really push it and you do all the things that you are required to do in a timely manner, you could get it done in 10 months, but on average it's 12 months. Some counties, it's a year and a half. So that's as to time. And then the last thing, which some people care about, some people don't care about, in a probate, everything is public record. So anybody could get in there, pull up the public record, see what that person died with, who it went to, what sort of things happened within the probate, any skirmishes, anything like inventories and appraisals. And, you know, as I say, some people don't care about it. Some people don't like that and want their privacy and that sort of thing. So those are all the things that are factors about the probate, none of which are considered positive. They're all considered negatives. So people say, well, I don't want that. Is there an alternative? Yes, an alternative is let me start with, there are other non-probate transfers, things like beneficiary designations on maybe accounts, life insurance. If those pass by the beneficiary, that's not a probatable transfer. Other things are joint tenancies. I'll have some folks that'll say, well, my husband and I, we own our house as joint tenants, which you should, if you don't have a trust. You say, so one of us would go first, and then we could then do something after that, maybe get a trust. And what I remind people all the time is, who are we to predict our demise? You could all leave here in a car, you and your husband, and both pass, or a plane, or whatever the case is. So we're not really in a position to predict our demise or how that will go. So you're taking your chances of assuming that one of you is going to go that way, and that you will be able to avoid a probate. Another thing that's worth pointing out is, it doesn't matter whether you have a will or not, so long as your gross estate is 150,000 or more, your estate is subject to probate. So a will does come into play, and it is an important document, but it doesn't keep you out of probate. So people do trusts, and the idea of a trust is, if we put our larger valued, significantly valued assets into the trust like a vessel, that when we die, it passes without the probate. It bypasses probate, and that's what the purpose of the trust is for, and that's what it carries out. The trust, what I'm talking about, is a family revocable living trust. To be clear, there are different types of trusts, and there's different reasons for those trusts. There's irrevocable trusts. I'm not talking about that. Irrevocable trusts are used generally in limited circumstances for things like people who have a disabled child, somebody who perhaps has a child with mental health, drug and alcohol problems, behavioral problems, money mismanagement problems, those sorts of things. Or they're part of a larger plan if your estate is over the estate tax limit, and we do more exotic sort of bigger things to try and break up that money. Maybe we set up a family limited partnership, we do gifting programs, and we set up irrevocable trust. I don't want to go too deep into that. Right now, the federal estate tax is $23 million for a married couple, $11.5 million for an individual. If your estate is larger than that, then there's things that can be done that are just higher end, higher level estate planning to try and break up that money a bit and stretch that estate tax and that sort of thing. But what I'm talking about is a revocable family trust. It's not an asset protection vehicle, just so you know. A lot of people have different misconceptions and thoughts about it. And again, its sole purpose is to avoid probate. It's not in this case, going to benefit you from taxes. Again, it's not an asset protection vehicle. It is to avoid probate. So what are all the benefits of a trust? It's everything that's the opposite of a probate. It is, from a cost standpoint, the attorney's fees and costs associated with the administration are very minimal after somebody has died. The time that it takes, a trustee, as soon as they get a death certificate, can start doing things in terms of handling the assets, paying the bills, liquidating things, selling off properties, those sorts of things, and reducing everything down to however the distribution is going to go or be made. It's private. The trust is not a public document. It's not a public record. People don't know what you died with, who it went to. And for me, most importantly, it's not in the court system. It's not in the courts. There's no court involvement unless there was some sort of litigation between beneficiaries and trustees or something like that. It's not going to be in the court. So it's everything that's opposite of a probate. And that is the benefit of it. That's the attraction for it. And that's what people do it for that reason. And so that's what we're talking about. And that is arguably one of the more important documents of someone's estate planning, but there are other documents that are also important. They just do different things. You still need a will when you have a trust, and a will works with this trust, and it even refers to this trust. It's called a pour-over will, and it deals primarily with smaller things like personal property or household furniture, furnishings, those sorts of things that are not in the trust. You're depreciating vehicles. And so it takes care of those assets, and then it does other things. If somebody were to have minor children, you would in there appoint your guardians. Who are your guardians to take care of your children after you pass? And that could be the same person that's the trustee, that's the money person, or some people like the checks and balances of having a different person, or some people are better money managers and other people are better maybe at raising children. But in that document, you would name who those guardians would be. So, and then there's the pour over nature. When I mentioned it's a pour over, well, what that means is if anything should ever get left out of your trust, and this happens, and I don't know how many, a dozen and a half a year I do of these, where something gets left out and the will catches it, and what it sounds like, it pours it back into the trust, because maybe the trust is doing something. I mean, let's face it, there are every family's different. Every family has a different dynamic, and there are a lot of families that have maybe they're not the Brady Bunch, I'll just say. There are folks that treat children differently. Maybe they have one person that gets more and somebody that gets less. Maybe they disinherit someone, those sorts of things. And if it got left out of the trust and didn't get poured back in, then that person who wasn't supposed to get something may get something. And so this is an important thing. And here's a tip I will just impart on you as well, is you should know, while interest rates are high now and really nobody is probably refinancing unless they had a really bad interest rate, there will be a time where interest rates will drop again and people will begin to refinance again. Keep in mind that when you have a property in a trust where it belongs, if you go to refinance, about 50% of the time, the lender will take the property out of the trust for refinance, because you as individuals are the credit-worthy borrowers. They don't want to get into this whole trust thing. That's legal stuff that they don't really want to get involved with and make a mistake. So, and you guys as individuals, again, are the credit-worthy borrowers. So they want to take it out of the trust, put it back in your name. And sometimes the clients don't know. And so they don't find out till someone's died that it's in their individual names and not in their trust. And so through the will, there would still have to be a probate, but the good news is it would go into the trust back where it belongs. But that's something to think about. If you ever down the road have a trust and you refinance, keep that in mind. I always pass it on to clients, and then they will either ask the lender to put it back in their names, and some will and some won't. So, and for those that won't, we put properties back in trusts often. So it's a pretty regular sort of a thing, but that's something to keep in mind. So that's the trust. That's really what it does, what its purpose is, and what it's doing, and what it's not doing. And it's a very, very important thing, though. I think, again, for all those different things, the cost, the time, the court involvement, and the privacy or publicness, if that matters to you, those are all things that should be avoided if by doing this. So you have the trust, you have the will. We don't always die, but maybe we have an incapacity. And what happens in that case? Maybe there's a stroke, maybe there's a car accident and somebody's in a coma, something like that. Well, we all know life still goes on, unfortunately. There's still bills that need to be paid. People have things happening in their lives. For some reason, I don't know why, but it seems like a lot of people are in the middle of an escrow when something happens. And what happens with that? There's people that need to sign escrow documents and title documents and that sort of thing. And so if you didn't have a power of attorney, which is the other document that I'm talking about, a financial power of attorney, then somebody would have to get a conservatorship over that person. If you've ever heard of conservatorship, a conservatorship is the bad stepbrother to probate. It's another court proceeding. It's a lot of involvement, a lot of paperwork. It's very expensive. It's not fast. Yes, you can bring an emergency temporary conservatorship, and that is pending until a permanent conservatorship, but even that's not fast. And so that's what a financial power of attorney can do, is you can appoint persons to act on your behalf for financial matters if you're ever unable because of incapacity. Within a power of attorney, there's two types of powers of attorney. There's a power of attorney that's active now. For instance, I took care of my mom in her last 18 months. I built her a little suite in my house, a little bedroom, and I moved her in and sold off her house, and she lived with me, and I took care of her. And because I paid all her bills and I took care of her, her power of attorney was active then, now, immediately, because I needed to use it, and I would go to the bank and do things for her. But for all of us who are in good health, mental health and capacity, we don't need somebody at this moment to have powers over us. And so what we do is what's called a springing power of attorney. Think of it as a dormant power of attorney. Nobody has any powers that are effective now and never will unless there's an incapacity. That's a springing power of attorney. And so those are the two different kinds. And for folks like you, we would probably do that kind. Yes. Springing, like a spring. It springs from the incapacity, if ever. So that's what that does. Yes. It's really has to do with name. Some of the names have changed over time, and names, it's a good point, actually are different across the country. So durable is like an older sort of a name. It's just a statutory. It's sometimes in many cases still referred as durable. It's just a legal name. But it's your power of attorney for financial. It used to be a durable power of attorney was also a reference to what are now called healthcare directive, what I'm about to talk about in the next one document. But just as a factoid, in places in the East Coast, a healthcare directive is called a living will. Doesn't even make sense. It doesn't sound like it, right? So I have people ask me, I'm interested in a living will. And I said, how do you mean? What do you, a will? Well, I'm not sure. Somebody said I need a living will. I said, well, what are you trying to accomplish? Is this a will, or is this a healthcare sort of a thing? And maybe they're from the East Coast, or they have someone on the East Coast, but so different nomenclature. That's something entirely different. By the way, speaking of names and titles, you also probably hear things like a living trust. And all a living trust means is what it sounds like. You're making a trust while you're alive. That's what a living trust is. It's just made while you're alive. In the older times, when trusts were not as prominent as they are now, trusts would come through a will, and those were called testamentary trusts. Trusts that were born from a death, testamentary meaning a death, and from a will. Well, somebody figured out at some point, well, what's this trust really getting us? We still have to go through a probate. We didn't really, what did we really accomplish? We've gone through a whole probate then to go into a trust. And so we don't really see testamentary trusts too much anymore unless it's a trust like for a special needs trust. If someone has a child who's disabled or has a disability who receives public assistance in some way, we don't want to run afoul of the entitlement program, SSI, disability, whatever the case is, because those persons can't have assets. They can't, in most cases, own any assets more than $2,000. And if we dump money on them, they're going to lose their public benefits, their entitlements. So it's not through a will, but it's through their trust. A special needs trust is born out of that, and their money carries on into the future through this special needs trust. So in some limited cases, we have a sort of a testamentary trust in that sense. But the healthcare directive is the last document, all of which comprise what's comprehensively known as estate planning, is a healthcare directive. And this allows you to appoint persons to make healthcare decisions on your behalf if you're ever unable, and up to including end-of-life decisions. And you pick an order who those people are. You can make certain wishes in terms of organ donation, how you feel about that. If you have certain wishes in terms of burial and funeral, some people want to be cremated. That seems to be fairly popular these days. Someone wants to be buried at a certain cemetery. We have some clients that are Jehovah's Witnesses, and they have very strict sort of directions that they have. Scientologists have very strict directions, and other site people. So you're able to put those sorts of things in there, what you want, perhaps what you don't want. And that allows those persons you nominate to carry those decisions out. Oftentimes you can upload it to your doctor's office, and they will have it on file, and they can keep it there in case something should ever happen. And yes. Did you? Wow. There you go. I just did one the other day where somebody is donating their body to some fire burns, very specific research to do experimentation on tissue. I don't know what her connection is with that, but then we have some people, don't touch me. Don't like it at all. Don't. And it's a very personal thing. And we have differences between husband and wife. These are very personal decisions. And someone will say, I'm an organ donor and take whatever you want. We have other ones that say, I don't want anything to do with it. We have some in very same couples. I want to be cremated. The other one, I want to be buried. So it's very, very personal decisions. I've used my own with my mom that I mentioned, and I had to make an end of life decision to put her on hospice at some point. And even though I was the designated person, I called my brothers and sisters, let them know what was going on from the hospital, and got everyone's agreement that it was time, and it was the end. But ultimately I did that, and I had my document. So that's how that went. Oddly, I actually had a case years ago where I had in Merced someone who came to me that was the second agent, and the sister was the first, and the dad was on life support. He was 92 years old. And the son, this person that came to see me, was upset because the sister would not pull life support, and his health care directive said he did not want to be kept on artificial life support. Now, within this you'll see there's a definition in these things. It's not just life support at all. It's you go in temporarily because you got in a car accident. We're not talking about that. We're talking about a permanent, irreversible condition like your brain dead. So it was an interesting case. I went into court in Merced, and I presented the whole case that this is not what dad wanted. Presented his healthcare directive as the evidence, and got records, and I got declarations from Mercy Hospital in Merced that said his lungs had no elasticity, and if they pulled the artificial respiration, he would expire on his own, that he was on artificial nutrition, and he was on artificial heart, whatever machine that is, it kept his heart going. And so it was interesting because I wasn't sure how I felt about it at the end, because I got the order for Mercy to pull the artificial life, and we took it down there, and they did that afternoon within a couple hours, and he died in 24 hours. And felt a little weird about it because I thought, gosh, I got an order for this man to die, and I kind of had mixed feelings about it. And the client was very thankful, and he noticed I wasn't probably sitting well with me, and he said, listen, he says, you got to understand, you did a great thing. You carried out my dad's wishes, and my dad's wishes were in fact carried out. He never wanted to be this way. And so anyway, it was an interesting, I never had anything like that again, but just shows you kind of what that document does and its power and that sort of thing. So with all these things, this is what we all ought to do, whether it includes a trust, or if it's not a trust, at least a healthcare directive, a power of attorney, and a will. And again, a trust is like an empty basket. It's only so good as you put things in it. And so it's something that has to be maintained in going into the future. If you get new properties, more assets, you've got to make sure that they're titled and transferred into the trust. There's all sorts of assets, and they get into the trust by different means. Real property gets into there by way of a grant deed or a quitclaim deed that transfers that property into the trust when you record it. You could have accounts that get into the trust by way of beneficiary designations. You can get things, interests like in partnerships, interests in certain LLCs, that sort of thing by way of assignment. Documents called an assignment. So it depends on what the asset is, but they all get into the trust by different mechanism or different means. For the guys in the back, I think they'll concur with me that there are a couple types of assets that we don't like to see in the trust, and I'll let them expound on those reasons. But retirement, I call them products, assets, things like 401ks, IRAs, I think annuities as well. Do you guys want to talk about why we don't want to have those in the trust and have them work outside of the trust?
So basically, with an IRA, 401k, any kind of retirement account, with an annuity, you have named beneficiaries. Okay, we always want to leave the money to either our spouse or children, maybe, you know, brothers, sisters, if we don't have children. And those beneficiary designations on those retirement accounts supersede anything else. Okay, so if you have an IRA with LPL Financial, that's where we are at, okay? And you have a living trust. And if your living trust says, you know, I want my assets distributed this way, when you pass away, all LPL is going to look at for your IRA are your beneficiary designations. But those assets do not go through probate. Okay, so the living trust is to bypass probate for non-retirement assets.
That's right.
When you have a named beneficiary, then it will go directly to your beneficiary, but it also will not go through probate.
And you know, I think that for retirement's tough. Retirement's hard. For those of you who have retirement, you've worked a long time to build up your retirement. It's actually kind of nice, I think, for a beneficiary to be able to receive the retirement.
One other thing on that, I've done seminars on this topic for years, and biggest challenge or mistake I see over and over again are people not having beneficiary designations on their 401ks, on their retirement accounts, okay? Now our job is to with any of our clients, is to make sure we have a primary beneficiary, make sure we have contingent beneficiaries, make sure we are asking our clients to see the beneficiaries on their 401k. Okay, here's an example, just happened in Rory 3 weeks ago, okay? My son's best friend, my son is 28 years old, okay? And I consider him my second son. He has been my son's best friend since they were in 3rd grade. He died suddenly on Valentine's Day of this year. 28 years old, this young man was very financially successful for a 28-year-old, had a sizable 401k already. He was engaged to be married. They were going to be married in May. And in fact, the day after he passed away, my wife got the bridal shower invitation in the mail, okay? Because they weren't married yet, he wanted his 401k to go to his mom, but he didn't have any beneficiary designations on his 401k. We just found that out 2 days ago, right? 28 years old, he hasn't done any estate planning, and he hasn't even gotten married yet. They did buy a house, but my 28-year-old son has learned quickly how important some of these things are, but that's how we learn in life. A lot of times bad things happen, it's like, oh my gosh. So right now is the time to just know this stuff. And if you have grown children, all my children are 28 is my youngest child, in their 30s, ask them, because if they're working for a corporation and they have a 401k, who do you have named as beneficiary? No, I'm not looking for the money to come to me. I just want to make sure that you have a named beneficiary so that it does not go through probate.
Because that's where it's going to go.
That's what with her, that's where it's going to go.
And it's a shame.
Indicates how the payments would go, spouse, children, etc. would that kick in even if somebody did not have a beneficiary noted on their plan?
Well, any plan is basically, there's some company who administers it, correct? And that company is gonna have a beneficiary form. So you just, when you get your statement in the mail, most 401k statements have beneficiaries listed. You wanna see those on there.
But if they don't, because we
That's a question to ask.
would ask too.
That's.
No, I was listening. So what she's saying is the plan document says that if. So you have your primary, so if you're married,
Yeah.
your spouse is automatically gonna be next. Then after that, it's gonna be your children. And then after that, it would be your next of kin. So the problem would be, is that if you don't have any beneficiary listed, then they would have to go ahead and do the
And,
research. It's not gonna happen automatically.
and what if you don't want, there are many situations, okay, I've got 3 children. And you want one child to get 40%, one.
That's out the window. If you don't.
No,
put
that's what I'm
in-
saying, that's why you wanna make sure the
Oh, yeah.
beneficiary designations are.
If you don't have any.
No, if you don't have it, then they're gonna do it based on the plan document.
Sure.
They're gonna take a lot longer and they're gonna research it.
Yeah.
I don't know that it has to go through probate though.
If you reach a point where there's either no beneficiaries at all, or the beneficiaries that you have listed have passed and there's no other contingencies, or the contingent ones have also passed, if there's none at all, it will go to probate because there is nothing left. Now, one of the things that you can do, while we don't want these kinds of accounts in your trust for the different reasons, it doesn't hurt to name the trust as the ultimate backup. So at least it doesn't go into probate. We're talking about, when you talk about the ultimate backup, usually you have your spouse, you've got children, and those people that are close to you, maybe even parents or siblings. But at some point in time, that's your heirs at law. I mean, whatever my bloodline is. And I think it's okay at that point, if everyone's died off, then to at least have it come into the trust or go by way of the trust and avoid a probate. So, but yeah, that's, I think, a really important point. And people need to also, if I can just say this, because you'll hear me refer to this stuff as a shame. People who have a trust that didn't transfer a property and then into it, and then it gets probated. Well, that's a shame, because you had a trust, you know what I mean? And so it's also a shame, and I see this frankly too much, is someone got divorced. They just never got around to changing it. And it was a bitter divorce. And I've seen somebody who was the person who died, the one person they probably hated more than anyone else in this life, get $1 million, and to the exclusion of their children. And then have children say, well, listen, Mom, that was supposed to come to us because Dad changed everything else. And it'll all come to us. So surely you're going to do the right thing. No, I'm not. Well, there goes the relationship with the daughters. And all of this, and I just see lack of cleanup, and that's a shame. Yes.
Family trust, the last 8 or 10 years, quite a while ago, and I felt pretty comfortable with it. And I was just wondering, it wasn't done by an attorney, it was done by a person that writes documents to that nature. And it wasn't cheap by any means, but I felt comfortable with it. I think all the bases are covered, but I was wondering if there is a published checklist for that specific type of trust, revocable trust, that we should be looking out for. And anybody that hasn't written one should be able to read it and
I don't think there's so much of a list. I mean, there are basic things like, are there beneficiaries that are appointed that are alive and contingent ones? Are there trustees and successor trustees appointed, and are all of the assets that need to be in or connected to the trust connected to it? Those are the primary I guess concerns. But everyone is different. I mean, there are a lot of people that are in the same group. There's a lot of people that we have a home, we have some savings in the bank, we have some retirement account. There's a lot of folks like that. But one of the things I will tell you, it's always worth a review, because I say this to folks, listen, I don't have pride of authorship. Somebody comes in with a trust that somebody else did 5 years ago, I will look at it and it's different than the way I do mine, but not different. So in structurally that I think it's got a problem structurally. You know what I mean? That I think it's set up correctly, but just different. And so it's kind of like a car. Well, there's a Mercedes and there's a Honda. They both drive. You know what I mean? So if the trust works, the trust works, and it's okay if it was done by a document preparation. I will warn you though, you do get what you pay for, and be careful about legal Zooms, because legal Zoom, you know, they do the very minimum. I've received people who, after they've died, my parents went to legal Zoom, here it is. I was like, it's not even signed. Or even if it's signed, there's no assets that have been transferred to it, because legal Zoom doesn't do that. Or whatever the case is. So I've repaired a lot of them, and I've seen some bad situations with like a legal Zoom that once again it's a shame. They went through the trouble, but you know, they got what they paid for. But let me say what I wanted to say just real quickly on what you were getting at. I do find some, and I just had one here recently, where there's some older trusts that are AB trusts. It's a type of a structure of a trust. And the way that it works is when the first to die dies, it sort of just dumps on the survivor everything else, or the survivor gets there's a disclaimer trust saying, I'll take everything unless I disclaim anything. And then it goes into a separate trust. What I don't like about that is life is life. I'm sure that we all would want our spouse to continue to live life and live a good life. I mean, I know that we would all think that, but not on our dime. You know what I mean? No, to dump all the assets onto the spouse so that he can go run off with pretty young thing when he was a little lonely, or she runs off with big sexy, you know, whatever the case is, that's fine. But why should the spouse who died, you know, pay for that? So what I like to see in mine, and this is where, to answer your question, I think that if the structure is okay and everything is how it should be, then I'm okay with it, even if it's not the way I do it. But if I see the structure, I like my structure. My structure divides when the first dies into halves. The one who died first is irrevocable and can't be changed. So the survivor can go, whatever it is, run off, or maybe it's not even a run off. Maybe it says, that surviving spouse, as I've seen, has had a falling out with one or more children. So they want to disinherit, but dad didn't have a problem with any of the children. So I like the separation of trust, and the decedent, the one who dies first, their half be irrevocable and non-amendable. And so at least their share goes the way that person wanted it to. And if nothing nefarious or anything ever happens, my mom never remarried or, you know, dated or anything like that, and two halves equal a whole. It's to her children equally, and it works out. So anyway, that I just wanted to say that about that. Yeah, Vince.
I was just gonna say it, in the irrevocable side, say that happens.
Yeah.
On the irrevocable side, would there still be a provision that the surviving spouse could use some of the income or assets to maintain their life?
Yeah, excellent question. Absolutely, to the extent that they need it. So what the document my type of trust would say is that the survivor is allowed to invade the decedent's side so long as they first spend down their side. Obviously, you don't want them to run a circumvent, spend down that guy's side and say, now I've got my side to go run off with. You can't do that. And in that situation, you see children suing parents.
And it wouldn't be the surviving spouse, right?
It usually is. Yeah, but if they have children, and let's say they had children, and children on dad's side were supposed to get 100% or some portion of it, and mom circumvented or mom did something and then mom goes and runs off, those child have rights against her. You know, so it's meant for the protection of the one who died first. And I think that's good. I don't like those situations. I've had too many people sit in my conference room and say they throw some documents in front of me and you know, mom died and here's a trust. Okay, so it's one of those trusts. Everything went to your dad. Okay, so it's your dad's got everything. Well, so that's the first part of it. So he went and shacked up, and this is a true story, with a gal in Oregon in a trailer and her 3 young kids, and he made a trust with her and he's given her, do you have that? Yeah. Well, you're out. He's given everything to her. That wouldn't have happened with my structure, or at least half of it. You see what I'm saying? And it's tragic. And so they're sitting there, these young women, 21, 22, 23. So we don't get anything? Sorry.
Can you take a second? Because one of the questions we always get asked, I'm not trying to multitask here. Yeah, rewind. Oh, I got enough. Seth. Can you talk for a second about like transfer of death, like brokerage accounts, checking accounts? What's your opinion? Can we name those in trust so people, you know, that kind of thing?
Yeah, so what Tom's referring to are non-retirement accounts, your brokerage accounts, your money market accounts, cash accounts, things like that. You have 2 options. You could make those trust accounts at that level. And so they're in the name of the trust and they're already in the trust because they're set up in the name of the trust. And that's okay. I prefer that the accounts be left in your individual names and that the beneficiary of that account is the trust. And then when you die, it goes to the trust on death, on the TOD that he's referring to. And the reason I like to have the accounts be in your individual names, well, first of all, for ease sake, they're probably in your individual name now if you've already got them. So it's not a big fuss to just change a beneficiary designation and to the trust, and that's all you have to do. But secondarily, powers of attorney, financial powers of attorney are ineffective against trust assets, trust accounts. So something happens and somebody needs to access that account that's in the trust, if it's titled in the trust, that person, that agent under your power of attorney cannot access that money. There's a wall because it's a trustee's position is called a non-delegable duty. You can't delegate a duty of a trustee. These people would have to be trustees in order to get it. Well, I don't like the fact that they have to be trustees to get into my account when this was a temporary or incapacity or something. I'd rather see them be able to access the account by way of the power of attorney. So if you leave it in your individual account, a person, an agent is able to get into those accounts or access those accounts by way of the power of attorney. So that's how I like to have it. But you know, as long as it's connected, if somebody wanted to put it in their trust, and we do have some people that do, then that's okay too. I do think that within the trust there needs to be something temporary though, like they call them a special trustee, which is essentially a trustee who comes in under limited abilities and limited times in the event of like an incapacity like you're talking about. I just think it's easier if you leave it as an individual. Yes.
My mom and dad had a trust, and within that trust, there was a clause that stated they could create or designate a power of attorney. Because my mom was the last to pass, and because of that clause, I was able to, she designated me as power of attorney to deal with one of her trust accounts. It was with one of her banks. It was under the trust name. Within the trust that had that clause, so when I took the documents into the bank, they were satisfied with that and they allowed me to be power of attorney for that account, even though I wasn't the first successor trustee.
Did she have a separate power of attorney that you were acting under? It's a little unusual situation. It sounds kind of like a special trustee. However it was called, it's what we call a special trustee. So thankfully she did have that because you'd have been stuck.
Yeah, well, yeah, because my sister was the first successor trustee and she lives down south.
Okay.
I lived here,
Uh-huh.
obviously locally, and basically took care of all her finances when she was in her later years, and then when she became, incapacitated and bedridden. That's when she did the power of attorney for me to be able to deal with that account and draw money out of it as we needed it for her care.
Okay. So it was in the account was in the trust.
Trust, but the trust had a clause, saying she could designate the power of attorney for.
So that's the one way to do it, or the other way is to leave it in her individual name. She could have left it, and through a power of attorney, you could have. So it's one of the two.
This was a bank account that had a larger amount of money, but once my dad passed, and it was their main business account. But once my dad passed, she opened her own personal small account that she did her day-to-day stuff with, and she just made me as joint owner on that account.
Right.
So even after she passed, I was still able to access that account.
Okay, good. The main thing is that was all set up with all those things in mind, and that's the overarching. However you do it, there's different ways to do it, but thankfully she did set that up in a way that let you do what you needed to do to help her. So yeah, that's great. There's within everybody's trust, again, everybody's different, even though a lot of people fall structurally within the same sort of type of trust, probably versus, high-end sort of estate planning. But within that, there are different things that can be done depending on what people want to do. Again, people can give to their beneficiaries, whether they be children or other people, disproportionately. Some people can leave money to somebody outright. Maybe you're able to, maybe you want to designate a certain age. Definitely have to be 18 at a minimum. You'd have to have anyone who's a beneficiary have their share be held in trust until they turn 18. But for a lot of people, 18 is too young. And so by far, 25 is the age that most people choose. We see 28 a lot more because one spouse says 30, one says 25. So you can see how 28's developed. And so that's been a popular one lately. But if you don't do that on a lot of these, even Tom, something that we talk about when you think of beneficiary designations, that some people have them on accounts. Again, first thing we want to make sure is this transfer going to avoid probate? So a beneficiary designation, yeah, it does. You got to make sure though, and it's a real tricky area when you're talking about the 401ks and retirement plans where you want to name those kids, and hopefully they make it past 18. But even if you name beneficiaries on accounts, and even if they're under that, then you'd have to set up a guardianship. Has anybody heard of a guardianship? A guardianship it's like the opposite of a conservatorship. A conservatorship is having power over somebody who's over 18. A guardianship is for somebody who's under 18, and because they don't have any rights, and so they can't have money. Problem with a guardianship is it's extremely rigid. It's a court proceeding once again. There's reports and accountings that have to be done every year until the minor turns 18, and then then if they ever need money, which you'd think they'd want to use their money for their health care and maintenance, they have to go into court and apply for that something very specific. And I have seen stuff that I just in court, you see all kinds of other matters before you, and I've seen the guardianship, someone applying, and some kid got his teeth knocked out. I can't remember doing what, skateboarding or something. I'm listening in the court, and so they're asking for certain dental work, combinations of implants, veneers, things like that to sort of reconstruction. And the judge is literally up there saying, well, why do they need all of that? What about braces? Well, it's like, and they're asking for like $5,000, and apparently there's like over 100,000 in it. And she's battling the judge, and the judge going, well, I mean, I think I'd like to see you redo your petition without these parts, And the braces can wait, right, until they're after 18. Why don't we just, yeah. So that's where she was going. She's okay with the implants. She was okay with the implants. So basically what they were gonna do was stick some implants and then give the full veneer. And the judge is saying, well, why can't you just fix what needs to be fixed? And I'm just sitting there going like, holy smoke, this is a topic, this is a story from these seminars. And so that's not good. And then also when they turn 18, the money gets dumped on them versus if it came into a trust, if they were under 18, it would just be held within the trust, no guardianship. And it wouldn't be, and then they could use the money, the trustee could pay so much for the health maintenance support as that person needed until they reached whatever that designated age is, 21, 25, 28, 30, that sort of thing.
Paul, could you name a custodian or under the Unified Gift of Minors Act?
You could.
Certain age, would that?
It's just, yeah, it's still not the preferred method. Listen, I think about when we talk about the trust, what is the idea of the trust? It's that we are taking control of our affairs on our own account. The government has a program for you if you don't take care of your affairs in life. It's usually not good. And so what all of this comes down to is you can take your affairs into control in your own lives and you can control your own destiny and do those things. Or you can say, I'll take the default programs that they're going to throw at me, the guardianships, the conservatorships, the probates, that sort of thing. So it's kind of what it all has in common. I think that if you're doing all these things, I wouldn't do it that way. If you didn't do these things, then yes, you would. Yeah. So two things I will tell you, not to sound lawyerly, but it depends. But I do want to point this out because I will tell you that I'm a different breed, and I am a transparent lawyer. I am a practical lawyer. And I think I'm a fair lawyer I've been practicing for 25 years and my business is built upon longevity of clients. I'm proud to say I still have my very first client from 25 years ago. Literally, and she trusted me to set up a corporation. She owns like 4 businesses now. She has referred a gazillion people to me, friends, family, people, and she's I've risen with her and we've gone through all her successes, helped her buy real property, business stuff. But most lawyers will never tell you. You have to come in their office. You have to do all that. So I'm one of the few lawyers that I'm telling you because most lawyers won't tell you. So on average, for folks that have a pretty, what would I say, straightforward estate, which really most of us, we own a house, we have some savings, we have things like that. Maybe even we have a couple rentals, that sort of thing. On average, it's about $3,500. And for a married couple, for a single, it's $2,500. It's $1,000 less. So that's those are my prices here. And again, when you compare that, again, let's take $1 million estate, $50,000. And I mean, that when I said it was exponentially higher, I'm being literal, it's exponentially higher. We have clients that have high net worth clients. We've got dairy people, pistachio farmers when I say high end, over 30 million, 50 million, that sort of thing. And they are this sort of program that I'm talking about, but elevated. They then we incorporate family limited partnerships, gifting programs, irrevocable trust. So they have more, and those can go up to $25,000, something like that. But we're also helping them save maybe $10 million. So, but on average for most people, it's that. And I will tell you that, economies are economies. In my Irvine and San Diego office, it's 5,000 and 3,000. Yeah. My hourly rate's $450 an hour if it were that sort of thing. And I think that I do a lot of that stuff. And if there were more that needed to be done, we could talk price is in terms of redoing things. Do you need some amendments? Do you need everything remodeled, or is it just amendments? You know, kind of like when you deal with a house, you can make some repairs or you can do full remodels, and it depends on what people have. As I was mentioning to this gentleman, if I see something that I see in a trust that needs structural change, then I think it's worth changing to something that has that better structure. If once again I see, well, it's not my trust, it works, I think it's okay, and it's doing all the things you want it to do, then I can tell you that it works. But certainly just a review and giving some counseling and looking through all the documents and talking about, you know, the life and all the different moving parts and making sure everything is put where it goes and everything's in its little cubby holes, then and that's usually about an hour meeting, something like that. You can ask all the questions you want.
Person that they call to say, if I have minor children, how do I put them as beneficiaries? So I heard you say guardianship, the custodian, which is what we have recommended a lot. That your ultimate is a state. Is that what would your ultimate recommendation?
Oh, well, and I really mean more for a pension is, I would put in the side of retirement. It's not, and I'm talking about non-retirement type stuff, really. But I think in that case, my experience with pensions, we're dealing with CalPERS and counties and that sort of thing. I don't know how your pension works, but okay. Okay, are you referring to it literally as a pension or generically as a pension? Okay, I'm sorry, then I was going down the road of a literal pension, because the reason I was going to say that is what I see in pensions, CalPERS and all those, you know, the plumbers and this and that, they get something during their lifetime, and depending on how much they take, you know, there's a dial that the spouse gets what's left. But then when it's all said and done, that spouse dies, it's like a $500 payout. There really is nothing after that. That's why I was latching on to the pension part.
If they just have minor children that they want to leave as beneficiaries on their 401k and ESOP, what is the safest way for them to do that if they don't have a guardianship already set up for their children?
You know, that is what I refer to as a little of a blind spot in everything that we're talking about, and these guys could possibly chime in too. I still think the overriding thing to do is to name the minor children. But there's a little bit of blind spot when we talk about, you know, is there a guardianship involved? What are your guys' experience when you have, say, a 401k and it goes to a minor child? What do you see happening?
So Paul, that's where I reckon custodian in Unified California.
I think you'd have to, yeah.
To the age, say, 25.
Yeah.
So in California, you can go up to 25.
I think that's what you would do.
But that's how and that's kind of what I was referring to.
Yeah,
earlier,
yeah.
Was a 401k.
Yeah, and so that we are clear, that's only that instance that we're talking about. If this is a non-retirement asset, then it ought to absolutely come into the trust and let the trust do the work. That's why when I mean it's a blind spot, it's not perfect. Yeah, did you have
We come across it all the time.
okay. Yes.
So if the pension, if it's a straight pension, not a public pension, like a school employee, but a private business, is a pension treated the same way as an annuity?
Well, again, a pension to me is a term of art. A pension is something that you, and I've seen there's hybrids, but not necessarily like a 401k that you're contributing, like a public.
Yeah, it's
A true pension, like a PG&E worker, a welders union worker, a CalPERS worker, a trans, you know what I mean? Those kinds. A county of Fresno, and then county of Fresno has a pension, and it also has another component where you contribute. I'm talking about a true pension as a term of art. Those usually have just a very small death benefit, and there's really nothing that goes beyond that. Once the person dies, then it goes to the surviving spouse, and how much goes depends on how much they took out. But after that, it's over. So that's why I'm asking if you're talking literally term of art, a pension. then I don't really think there's much to consider about children.
Yeah, so the defined benefit plan pensions are funded totally by the employer. And so what they're doing is guarantee you a certain income when you pass, and then you could also include your spouse if you want. You could have you could have that included. In other words, it'll pay out until the employee passes, and then it could go to the spouse. But then once it's done,
That's
it's
it.
done.
That's what
Then
I'm
it goes
saying.
to the kids.
Now, if you have the option to cash it out and put it into an annuity, is that treated any differently?
Well, if you have the option to cash it out and put it into an individual retirement account, then you can manage that separately, if they give you that cash out provision. Like I used to work for John Hancock, and they had a pension like we're talking about, a defined benefit. But because they're so expensive, you don't see a lot of those anymore, unless it's a government agency.
Right.
What they did is they ended that, and they gave me a cash out, of which I rolled it into an individual retirement.
Okay.
And you manage it yourself.
Okay.
And then all the same things about children we just mentioned there would apply.
Nick, you said on the brokerage accounts, so if you have a brokerage account that has, say, CDs, stocks and ETFs,
Mhm,
if it's under let's say under just my name,
mhm.
can the beneficiary be the trust?
That's what I like to see. I like to see it set up that way. So it comes into the trust on death through a TOD.
They have to sell the CDs, the ETFs, and all that, or can they keep that going under the trust?
I have seen them keep it going, and they just set up new accounts, I believe is what they do. And then depending on what the shares, they have them come in, and I've seen it in kind, the word in kind, meaning non-liquidation. Right, it's,
They have the financial power of attorney to go in and assume the account after.
no, it would be, if the trustees would do it through the trust. And they would make it through distributions by setting up these accounts and then distributing. We still have people that, what is it, computer share? For people that have still the old school, they actually have PG&E stock, not through a brokerage account like a Charles Schwab or E-Trade or anything like that, but they have the old school actual just shares of stock. And those can be transferred in kind as well. And I think you've helped us out with some folks like that.
Life insurance. Life insurance, where it's not whole life, is that something that goes into the trust or is that separate?
We like to see that go into the trust by the same way you just mentioned on the brokerage, through that beneficiary account that will come in, and whether that's a whole life, a term life through private or through your employer. And I know some people will say, well, I just have a 15,000 or 100,000. It all adds up. So I think you ought to do that. And again, the trust does all the work because it has all the contingencies, it has the age restrictions, it has all of that stuff. So if we can just have it connected to the trust and get it into the trust, we really want to let the trust. We don't want to have asset by asset doing different things or having, when you want to make a change, you just change the trust and everything associated with it is changed in effect, versus I need to change this account, I need to change this account, all because you want to change a beneficiary.
So bank account, brokerage account, or life insurance account, basically put down the trust as the beneficiary, not your wife in the trust.
Correct, because it already provides for your wife and everything within the trust itself. And so the other part to it is you're going to leave it in your individual name. And you'll also have really easy use as you currently do. Yeah.
Any questions online?
How effective are no contest clauses in a trust?
That's a great question. It's a bit of an academic question at this point. He's asking how effective are no contest clause. So generally speaking, they have historically been honored and have been affected and currently still are. I will tell you now, there is a movement in the legal world where the courts don't like them. The idea had always been that the purpose or the idea of a no contest clause would put a barrier into somebody from challenging it, and therefore reduce litigation, reduce court actions involving this. And so then there became a point where people said, well, how do I know if I'm contesting? You know, am I over? Am I not over? I'm just asking questions about it. I'm not contesting it. So then the courts came up with a procedure like a safe harbor where you could put what your issues are. And if the court says, yeah, they'll make a pre-ruling that this is not a contest, you're safe, you can go on with your litigation, or no, this would be viewed as a contest and you would then, be out. The courts have found there's been more of that. And so the whole objective of the no contest, that it would reduce court actions, actually has been the other way. It's increased court actions. And so there is the law and the courts now are starting to water down them. Some courts are starting to either not enforce them at all or limitedly, enforce them a limited way. And I think the prediction is in, I don't know, 5-10 years, they will no longer be enforceable. At some point, California legislation is going to probably step in and say they're no longer enforceable. Yeah, good question. No, that's a very currently evolving topic. Yeah. Yes.
How often do you recommend revisiting your trust if there's no new assets or no like changes just because laws change and things like that? Like how often do you recommend?
So I think that if you have a trust that is got good structure, it's a solid trust in terms of the way it works. And if you don't otherwise have any changes in your beneficiaries, your trustees, assets and everything are fine, even if to the extent that they have changed, then you certainly don't need a year by year. Someone who has a trust that's maybe done more than 5 years ago, 10 years ago, we start to see these things outdated more along the line of, while they don't have any changes in beneficiaries or trustees or assets, again, it's a structure that I don't really like. And so therefore it's kind of a landmine. And that may be a reason for it. So, but if it's something that's 2 or 3 years old, if it's something that I've done, even my stuff has changed and evolved over the years, but it was never like that. I don't think it's something that needs to be reviewed very often. Yeah, not just because you have it, but at the same time, I do review stuff with people often, and kind of what we talked about. Some people just want to make sure that everything's in order, that sort of thing. And then I have the little old lady that wants to review it 3 times a year, which we really don't need to review again. I think she just wants to come in and see me. Yeah, they just want to have coffee.
A question, pertaining to assets where you were mentioning, does that also include assets that are involving in another state?
Yes, they can. His question is, does the trust involve assets from another state? I think they ought to all come in here. And so when we talk about probates are of assets in California, and every state has a probate system and procedure. And so you could, and some procedures, as you can imagine, are pretty light. I had somebody, I think it was in Massachusetts or something like that, and it was like a 1-day probate. I'm like, what? Yeah, there's a house. And that's ours. I said, wow, well, ours is not like that at all. But I think if you're going to set up a trust, why not? Why not have everything connected to it, and not take that chance of going, well, what's this state's laws and what's their probate like? You know what I mean? I think it's just safe, and it makes sense to do that. Now, I will tell you, you didn't ask this, but I'll take one step further. International properties are more difficult. I will tell you, I wrestled with a property in the Dominican Republic, too many hours, and I just forget it. It's way too much of a process. They eventually hired a lawyer in Dominican Republic, and he even said, it's too much. And so we have clients that have property in India, in Europe, and different places, and I don't know how to do it. I'm not an international lawyer, and it's just, but other states, and myself and my office, we fund properties all over this state. Every state, I think there's not many left that we haven't done, some more than others, but everything from Hawaii, of course, Florida, Montana, Michigan, Texas, and they're all a little different, but they're all very similar as well too. Last couple things I want to say though, that are worth pointing out is, for any of those of you that might be wondering, a transfer of your property to your trust it does not affect your property taxes. So generally speaking, in California, the transfer of real estate is subject to reappraisal. Reappraisal means bringing it up to the current value, and therefore your property taxes go up. A transfer to a trust is one of the few exemptions. And so your property taxes will not go up as a result of that. Someone, yes, Daniel.
Zoom question.
Oh, great.
For a young couple possibly considering a prenup, would there be any special considerations when setting up a trust? Does one hold more weight in general, and do both avoid probate?
I think that's a great question. So, there are two different animals, the prenup and the trust, and depending on what the people want to do, and of course, let's obviously start with the idea of the prenup, which is generally speaking, what's yours is yours and what's mine is mine. And there are different reasons that people have prenups. Maybe that they somebody has done better in life sooner and has more assets than the other person, but sometimes it's because they've inherited a lot of property and they want to do that. And that's separate property. That's not on the table in marriage. And what I will tell people, if there is separate property, they don't even need a prenup. That's not something that's on the table for divorce because it's not community property. But what I've seen with it is I've seen two different examples. I've seen people with prenups have a joint trust still. And because maybe their prenup says the house we own together, that can be community, but everything else, what's mine is mine and yours is yours. Kind of depends on what the prenup says or what the extent is. Some prenups are just, like I say, completely what's yours is yours and what's mine is mine. Some are different. These assets are ours, but those assets are yours and these assets are mine. So not all prenups are the same. And so I have also seen the prenups that are more stringent, like there is nothing you're getting that's mine. In that case, I've seen them each have their own trust. So I've seen it both ways. I will tell you this, I think this is kind of cute. This is a little corny, but I'm going to say it. I think it's cute. So I had a client who he's a very good client of mine. He just sold off a manufacturing company. He's done well for himself in life and has had a good life. And he calls me and says, I want to come and see you. And I said, sure, come on in. He came and says, so what I want to ask you is, what do I have to do to get rid of this prenup when I first married my wife 30 years ago? And I said, you want to get rid of it? And he says, yeah, I had assets when we got married, but it's been 30 years. We've had kids together. We've built things together. We've done it. And I don't want this to be anymore. I've never had anybody come to me and say, I want to cancel it. And I thought it was great. I thought it was the other side of the coin of a great story that you see. And I thought it was great. I said, does she know about it? He says, no. And I said, yeah, we can terminate this. And yeah, and he said, no, it's in the beginning, I didn't know. I don't know if this will work. And I had assets and she didn't. But now, 30 years later, kids, and they're going off to college, and she's been a great wife, and she's helped me build all this stuff and that sort of thing. And she was, I think she ran the HR for his business. And so she worked in the business and was and she's been great too. Anyway, I just thought it's kind of corny, but I thought that was great. What's that? They are still married. They are still married, and we waited. Let's see what happens now, right? Well, now they're entering the tough time because they just have sent off the youngest son to college. So now that the kids are out of the house, this is where it gets stressful. Yeah, exactly. That's funny. I didn't think that, but it was. Thank you so much. Appreciate it. Cheers. On Tuesdays days. Sure. Yeah. Thank you. Yeah, this looks to be a beneficiary designation. That's designation, that's right, that's right. And so it looks like this is your first and the second. Yeah, yeah. You're very welcome.